Well, one of the differences with Potter Clarkson compared to other patent attorney firms or IP solicitor firms is that we operate with patent attorneys and trademark attorneys and solicitors all working in the same unit. The benefit being that we have people with substantial technical expertise, as well as people who have expertise in some of the purer forms of litigation or licensing and other associated agreements. So you end up with that good mix of a technical background, people who understand the patents that you're working with, and then people who can help you understand how to exploit those to maximum benefit. So you've got everything in one place. So hopefully this will be a nice overview of the full life cycle of rights, from start to finish being wherever you want it to be, whether it's exit, whether it's, continuing to maintain it and running a company until you retire happy and hopefully wealthy. So if there's any questions on any of the stages that we talk about, do send those in. I think George is filtering those for us. And we'd be happy to answer those at the end as well. But hopefully we'll give you a good overview of some of the things we can assist businesses with.
Yeah, I think we've probably crammed quite a bit into the slides. So some of them we might rattle through quite quickly, but we can, if Olivia are happy to give people copies of the slides, and hopefully there's some stuff in there that will be useful, even if we don't get to cover it all. So we're going to try and talk about why you should care about IP, because it's expensive. Why should you bother spending your money on it? A few action points that you can take now to get yourself in a much better position for example, getting ready for investors. Briefly outline a patent application, because they are a bit of a strange document, especially when you're not used to looking at. Basically, when on my first day I looked at a patent application, like, why the hell is it written like this? It just doesn't make any sense, but it does. Talk through a little bit of a kind of a made up invention disclosure, the kind of things that we come across when we're working with early stage researchers, and then the kind of things we would ask back, because we find that often inventors and academics think the invention's this, but really it's this, and you want it to be this. So they're the kind of things we'll probably try and ask you. Things you want to think about with your patent filing strategy. A bit more in depth if we get into it about what you need to get a patent. So what is novelty and what is inventive step. The patenting process, which is probably not covered, but there's a slide in there that you can just it's got timelines, because it does take a long time to get something granted. And then cover post-grant actions and how you're going to actually use the IP that you've got. So our goals are that you're going to come away from this actually valuing your IP and making it a core part of your business and your business plan, not just something you do to tick a box. Help you to be able to identify your IP, because you will have got some, even if you think you haven't, you will have got something. Put you in a better position to engage with your patent attorney and your solicitor, the kind of questions you should be asking or looking out for. And a key thing to me, and we'll come on to this, is the data that you need to support your patent application. Because I'm very aware that in academic research, your grant says you're going to look at this and you go off down this route, and all your experiments are planned around getting this result. When actually, if in the back of your mind you can keep, oh, actually we might file a patent application, what kind of data do I need to support that? There are lots of little easy tweaks you can make to your experiments that can really help support your patent application. So thinking about that in advance to me is really important. And then what are we going to do with your IP and how you're going to exploit it to A, get some money, and B, get your product out there. That's the whole point. I think most of us went into research, and especially academic research, with the goal of A, furthering knowledge, and B, doing something useful, like curing cancer or saving the planet. And I know most of us think we can do that by publishing it in Nature. But the problem is, and I didn't realise this until I left the university, once you've published it, your chances of getting any registered IP rights that are gone, because your invention now is not new, and no one's going to touch it, because the whole point of having IP is to stop people copying you, and it kind of protects your space. So unless you've got those protections in place, an investor's not going to give you the loads of money that you need to get your business off the ground, when once you've got your product developed 5 years down the line, someone around the corner can just copy you. So you need those IP rights in place to get your research to make an impact. So this is just outlining the main types of IP, and obviously my background, so I'm a patent attorney. Patents cover the technical bits and the clever bits, so the inventive, clever things, and to get a patent, your invention's got to be new and inventive. There are also design rights, which can be unregistered, so they just arise, but there are certain limitations on those. And there are also registered design rights, so you have to actually apply for them. The designs just cover the shape and appearance of something. So if you've got a medical device, you can register the design, how it looks. The design rights don't cover the clever bits because they're covered by patents. So with all these different rights, basically there's a right that covers everything, but they're just different. And then they talk about the other.
Yeah, it's interesting. It's kind of a public policy background point in that you have a mosaic of rights here, basically, and the way you can protect certain aspects of your product and certain aspects of your IP is about selecting one or more of these rights in the right order to make sure that you're appropriately covered. So as Sarah mentioned, you've got the technical inventions, which are your patents, which are all about the actual functioning of that particular invention. The design is effectively purely aesthetic. It's much more commonly used in more industrial environments, whether it's automotive, for example, car body shapes. It may be aerodynamic, but that's not the principal purpose of it. It's an aesthetic consideration. On top of that, you have some of the rights you might be more familiar with, so trademarks, branding, logos, devices, things that demarcate your business in the eye of a consumer, whether your consumer is a person on the street, so an individual, or a business that you're selling to. One thing that's quite often forgotten is that even if you're operating on a business-to-business basis, having a strong brand identity can be a real point of difference, because if you're involved in an industry where a particular purchaser has a number of different options available, if you have a strong branding strategy and a recognizable brand and trademark, whether it's for your specific product or whether it's for your overall category of products, for example, people will call you to mind more regularly. You're more likely to generate more business rather than having a lot of disparate different names for things and no unifying identity under which you can trade. So it's important not to forget business-to-business branding, as well as the ones you're familiar with, the Supremes, the Nikes, the other brands who are there to all communicate with consumers. And these trademarks are registered rights, and they let you protect names, logos, words, sounds, colours, and they need to be distinctive of your brand and not simply descriptive of what you do. The classic is you can't have a trademark of a banana for a banana because it simply describes it. It would prevent other people from using that name to describe the thing, which is, again, a public policy issue. Confidentiality and patents really do go hand in hand. One thing Sarah's mentioned already is that if you published your invention in public domain, if you put it out in Nature, then it's no longer confidential. Everyone knows about it, and it's deemed to be what we call prior art in respect of any subsequent patent filing. So having a really sensible strategy to keep your valuable information confidential is going to be critical to your business going forward, and managing that appropriately is really key. In addition to confidentiality, there are trade secrets, and trade secrets are basically confidential information plus. So 100 people in your business might know some confidential information, whether it's your pricing strategy, whether it's the next product you're going to develop in real terms. Trade secrets are normally held by a very small number of people because they underpin the value of the whole business. The classic example is the Coca-Cola recipe, the actual balances and combinations of flavors, and it's something where apparently the actual recipe is only kept in physical format, it's kept in a safe, and only 3 or 4 people in the business actually have access to that safe. So that's the level of preservation we're talking about. So they're a special kind of confidentiality. You can keep something confidential as long as you want, which is another appealing factor. Patents, you have a limited period of time for which the government grants you a monopoly over that invention, after which everyone can put into practice the invention that you've taught them. It's a value exchange. You tell the world how to do something, and you get the exclusive rights to do it for 20 years to make your money back on your scientific contribution. Trade secrets have no end. As long as you keep them confidential, they retain that status. So some people choose to protect things in that manner. It's much harder to enforce, and there are lots of benefits to having patents instead, but the two regimes run hand in hand. Some of the other IP rights, copyright, so that can be underlying in the manner in which you record information. You probably most commonly see it in relation to music. There's a lot of copyright cases around who's used whose melodies, but it also can apply to particular collations of data. So you can have rights in data tables, for example, if they've been collated in a particular way. Likewise, data itself, you've probably all heard about the GDPR. I won't go over it again, but fundamentally data has value, as IBM and Amazon will continuously tell us. So every aspect of what you're creating at any point in an innovation process will normally have a way you can protect it. And knowing a little bit about the rights and which ones to pick to protect your innovations, your business ideas, your concepts, is going to set you pretty well up for your future business strategy. And investors will like to see a level of sophistication with this at an early stage. And if you can demonstrate you know what you're doing with this, there is inherent value in an investor being able to look into your business and go, this is extremely well organized. You know you need to protect various aspects of your business, and you've taken sensible steps to do so. So it's important not to underestimate any of these rights, but of course we do love patents. So we will probably focus a bit more on this as we go through. If you have any other questions on it, do just drop those in.
So I'm sure if you've looked into it, in terms of patents, it's expensive. It can be expensive. So why should you bother? We've said earlier, if you want to see your research make a real world difference, you need to check. That's the only way you're going to get as far as getting out of the market and doing what you want it to do is by getting people to invest in your company or raising funds other ways. But when you get there, you don't want people to rip you off because you're going to want to make a profit, presumably. So you need IP to protect your space. You need it to raise funds. You also need to think long term. So you might be sat there thinking, oh, well, I'm getting grants from Innovate UK. I don't need patents. That might be true now. But in 5-10 years, you might want to raise investment. You might want to sell your company. And if in those 5 years, you've told the world all about your invention and all the details, then you're not going to get IP to it. So you need to take that long-term view as, well, I'm not so bothered now, but 5 years time, I might. So I need to keep it confidential, get your IP in place. And you need to think, and I think this is on the next slide, but we can talk about it now. When you're starting out and founding a company, what have you got? You're probably borrowing lab space, borrowing bits of equipment. You've got no premises. You've probably got not much cash. You've not got much of inherent tangible value. But what you do have is your IP, and especially early on, that's your most valuable asset. And we've just had a client. So they're in clinical trials for an antibody therapeutic. So again, they don't really have much in the way of premises and stuff, but they've got 2 patent families to this therapeutic antibody, and they've just been acquired for $1.5 billion, which is essentially just for those rights to make and use the antibody. So, you think early on, 5-6 grand for a patent application is expensive because you haven't got much money, but a few years down the line, it could be worth so much more. And you do need to realize that early on, if you make mistakes because you're not really thinking about IP or you can't afford certain things, if you make those mistakes early on, they can be very difficult to rectify. I've got one client who's always all over LinkedIn and Facebook telling everybody about his invention. If you do that before you've actually filed a patent application, basically you're screwed. So just think about it.
That's a technical term.
It is. So this also, if you've not already believing in IP, this is a report done by the EU last year, by the European Patent Office, and it looked at SMEs across Europe and looked at the registered rights. So this is only rights that you can register, so designs, trademarks, patents. It's not taking account of all the confidential information, trade secrets, because by definition, you can't measure it. So they looked at the revenue per employee, and they found that companies with a patent, trademark, and a design right, so one of each of the 3 main rights, they had 98% higher revenue per employee. if these companies just had any of one of those, it was still 68% higher. And then when you look at these figures, it's just quite stark when you realise that actually 91% of SMEs don't have any of these. So there's quite a disparity in the benefit you can get, and then the like uptake of IP. And one of the things that the report put this down to was lack of understanding. So that's why we're quite keen on like telling people about it, because it is really important. And I know it's complicated and it's probably quite boring, but people need to, you know, be aware of it. So I was saying earlier, so you haven't got lots of stuff, but you do have your ideas, you've got your business plan, you've got some confidential information, because hopefully you've not told everybody yet, especially if you've not filed a patent application. You've got certain partnerships and collaborations. You're hopefully enthusiastic if you're setting up a business, because I expect it's quite hard work. So what you need, so all those are kind of intangible. You've got nothing that you can hold and show an investor. So what you need to do is get all those written down into kind of a comprehensive IP strategy. Write it down, and then you can present that to investors. We'll look at IP strategy in a minute. So we're just going to talk about a few action points that you can go home now and do if you haven't already done. You're going to create an IP register. So you're going to look at what you've got, whether you've registered anything or not. What have you got? You might have filed a patent application. Your university might have filed one, which you might be wanting to in-license when you spin out. You might have got a trademark. If you haven't, you can put that on your list as something that you should do. Is your technology suitable for a design right? Maybe, maybe not. You've probably got lots of know-how and trade secrets or confidential information that could be considered to be a trade secret if you take certain steps. So you need to get all this written down in one place so that when you come to meet an investor, it's there, ready. Like Dave said, investors want to know that you're well organized, you know what you're doing. So having it all ready is very important. So it can just be like basic information. What's your application? What's your application number? Is it granted? What countries has it gotten into? All that kind of stuff. Is there anything else you want to say on this slide?
No, I think with this, it's just a little bit of pre-planning goes a long way. We've worked with clients in the past where they're quite big clients, but they've not started off with the right structure. They've not started off with organisation, and they've come to the table to seek investment or buyout. And the investors have said, that's great. Set out what rights you have. Tell us what you've got. Tell us where it is and what it relates to in your business. What products does this IP relate to? How are you using it? How is it stored? How is it preserved? And this is surprisingly common actually in businesses of large sizes, but they basically terminated the investment exercise on the basis that the rights were so spread out across the various entities within the group. They couldn't provide a clear roadmap of what they've got and when, what products it related to. So even if you start early with a single product, start thinking about siloing your IP. So you've got product number one. What have you called it? Where's the data that underpins the product? Is that being kept confidential? Do you know where that is? Is there any copyright in any of the materials you've got? It might be an algorithm particularly, or some sort of source code that you use for analytics maybe. There are any designs that relate to it. If you can keep these things in a single organized space, and you start off with sort of good IP hygiene, you don't have to go back and try and reverse engineer these things. And from personal experience, trying to reverse engineer a portfolio of IP rights when you've got 3-4 years down the line, you're working with multiple products, will cost you a fortune in professional advice and professional time, and can, as I say, delay or otherwise break a process of investment you'd otherwise be involved in. So just getting these habits in place early and just keeping everything well organized, well set out, and if you can, tied to your IP strategy, is going to massively pay dividends in the long term. So, you know, all of these things are just useful regardless of what level you're already at.
So investors, and you just want to know this yourself, you're going to want to know who owns your IP. So the default under the UK law is that an invention will be owned by an inventor unless they are employed, in which case it belongs to the employer. When it comes to universities, this can get very complicated. And if you're talking to your tech transfer office, this is like probably one of their main headaches, because Universities are different policies, but the general rule will be if you're, say, a postdoc or a employed researcher, your invention will belong to the university. If you're a student, it may or may not belong to you or the university, depending on university and academic research is very collaborative. So you might have got 2, 3, 4, 5 even different institutes all working on the same invention. So then you can have 3, 4, 5 different owners of that invention. So you need to make sure that all this is documented, because investors will look at this very closely. If you have worked on something at the university and the university has no interest in taking it any further and they say, yes, we can do it, you need to make sure you've got that in writing, because somebody's going to want to see that they've said you can have it, and they're not going to come after you 5 years down the line when you're making millions of dollars to, say that they've got a claim on it. It's also important to note inventorship is not the same as authorship. So I know in academia, we all had our friends in the lab down the road because it's good to help people out. And if somebody's made you a plasmid, or I don't know, made you some media, you might add them onto a journal publication. But to be an inventor, legally, they have to have made a technical contribution. So although you might think you're doing your friend a favor by sticking them on as an inventor, A, they're not legally entitled to be an inventor, and B, that could mean another entity is entitled to ownership if they're from a different university. So it's something to make sure you think about, and it's all sorted early on. Make sure you've got your chain of title. So if something has been assigned to you, make sure you've got all the documents in place. If you've engaged a consultant, make sure the ownership of that's clear. Is it on the terms where they would take some ownership of the IP or not? You want to make sure it stays with you, preferably. And if you're going to have engaging collaborations with different institutes or different companies, get it all set out in advance. Don't wait until you've found something amazing and then sort it out, because it's going to be a lot harder.
Yeah, so I think on that, this is really common for collaborations, and it's really common when you're very early stage in businesses as well, because you won't necessarily have set up a company. You might be operating as an informal partnership. So you're working with 2 or 3 people who have all put a bit of money in to fund some lab space together. It's even if you've not got an incorporated company where you've all got an equal shareholding, you need to try and make these decisions and have these discussions early on, because it can cause problems later down the line. And in the same way where you have 3 or 4 universities working together, it's really important to have these discussions as to what is each of these parties bringing to the table, what IP have they already got and they're going to contribute, and what is going to be the output of this project. And a lot of that is just project planning that you might be used to already, but it's recognizing what value everyone's bringing to the table, and then what value you're hoping to get out of it, and then who's going to own that. It could be really straightforward. You could agree that you're all bringing something to the table and you're splitting it 4 ways because there's 4 of you, so it's 25% each. But if you don't have these discussions now, as Sarah said, hindsight is a terrible thing, because you can end up feeling your contribution was absolutely fundamental and the invention would never have happened without you. And everyone else could feel the same way. So everyone's fighting for a 75% stake and there's only 100% to go at. So getting all of this sorted in advance, particularly when you're bringing in consultants as well, agree whether they're going to own anything at the end of it before you even contract with them, because you don't want to be trying to reinstate these kind of terms later on when, as Sarah said, things are looking really good and actually the revenue stream looks much brighter than they were expecting, because people will naturally renegotiate at those points. So if you do all of this up front and you work with people who can advise you on the best way of engaging with other people and other institutions, then you'll find it easier in the end. Cool. So actually I'll carry on this one actually. So this is something where quite often, material transfer agreements will be things you just potentially even see on a weekly basis. You will continue to sign them because you want to keep stocks of relevant materials coming in so you can continue your research. What often gets overlooked is that these material transfer agreements, and sometimes even broader licenses to allow you to use specific compounds, specific antibodies, specific protein constructs, they come with terms, and those terms will be set by the company that you're buying from or licensing in from. And if you're not sure the basis on which you can use these constructs, then you might end up in a bit of a sticky situation when you try and commercialize and you realize that actually the material transfer agreements you were working under, or the licenses that you were working under, were for pure research purposes only. And if you want a commercial license, you need to go back and renegotiate. So generally speaking, there's a research exemption in respect of patented inventions. There are variations between countries, particularly in Europe. But if you're researching something to effectively work out whether the concept works or not, so trying to put into practice something under a patent or something that's partially under a patent, as long as it's for pure research and not for commercial purposes, you're okay to do it. And therefore, that's why most licenses will allow you to do things for research purposes for a relatively low cost. When you look to commercialize, that whole situation changes. If you try and do something commercially with something that falls wholly or partially within a patent, then there is a chance that you'll be finding a claim on your doorstep from the owner of the IP that you're accidentally infringing by putting a product on the market that contains their component, which is their proprietary rights.
I think,
yeah.
Sorry, I was going to say, I think there's a distinction there that you said. Because my understanding is, if the research exemption is, it allows you to do research into the thing. So say you buy an enzyme or get hold of an enzyme, you are allowed to do research into the enzyme, how it works. You are not allowed to use that enzyme in a method that would not fall under the research exemption. So then Dave's probably going to say the same, but I think some of the terms of these agreements are very broad. So you buy an enzyme, you're using that enzyme, this happened to one of our clients, you're using that enzyme in a method of screening, and your commercial product is actually the thing that pops out the end. So it's a drug. Nothing to do with the enzyme really. But the terms of the agreement, when we looked, a commercial product is anything that has been used, anything that has been developed using the enzyme. So the fact that this enzyme was used miles upstream of your actual final commercial product meant actually you were kind of breaking the terms of that agreement. Sorry.
No, it's right. And you do see these examples all the time. It might be so far down the chain, it's a screening method and it was used in, your initial screening processes, and you've gone through 4 or 5 stages of refinement, you've selected, far improved compounds, but because you used it early on and you use it in a commercial process rather than something which purely fell within the scope of what that product was intended to achieve, then you might find yourself on the wrong side of the license. And that's why having somebody looking at those, if you're looking to get out with the side and commercialize, maybe move to phase 2 trials, for example, with a particular compound, looking at the licenses you need in all of those trial stages before you actually start them is going to be a really sensible protective measure. And there might be these licenses, they might exist in things you don't even think, things you would normally buy in bulk from a catalogue provider, from a CMO even. They do have license terms that come with them. So it's a bit like the terms and conditions you click through on the iTunes page that you never read, but sometimes it's worth reading through.
Yeah, I think also if you're in this position, I think it's worth looking through your past publications, because in the US there's a court case from Allele Biotech, who was suing Regeneron for the antibody cocktail with COVID because, and this came about because I don't know how many years ago, there was a journal article by Regeneron saying they'd used this really bright GFP that was Allele Biotech's. So back then it was like in a research context, but now they commercialized the product, then they hadn't taken a license from Allele Biotech. So I think that's the only case I'm aware of to do with COVID. That's look what you've put already out in the public domain, because it could come back to bite you.
Yeah, exactly. Because in terms of, even if sometimes when you publish a patent, for example, when the patent gets published, you will have other companies trawling through and seeing what methodologies you've used, sometimes out of academic interest, and sometimes if they recognize your name from a customer list, they might just be going through and checking to see whether you've actually used any of their IP in the processes. But yeah, I mean, these things are often resolved as well in what we call pre-action skirmishes. So they might not be in published cases, but there are a huge number of examples where one party will receive an aggressive letter from a patent holder requiring them to take a license, and quite often the smart thing to do is find a way of settling that dispute before it goes to court. So the number of reported cases you get is only the tip of the iceberg in terms of the extent this can be an issue.
I think we're probably doing quite a good job of terrifying people into not doing anything at all, but that's not what we're meaning to do.
No,
I think a lot of times it's a commercial decision. Is anyone actually really going to find out that you use this method in secret, even if you are infringing? It's a decision you have to take.
We also shouldn't tell you this, but it's only an infringement if you get caught most of the time. So this is also something that we do a lot of, and between patent attorneys and solicitors is what we call freedom to operate. And it's a risk analysis of what your product is, where you want to put it in the market, what does the landscape look like, who else is playing in the market, and who might cause you problems. And if you work with people who know the law and know the industries well, then you will also get advice. I'm not saying this is formal advice, but you will get advice that this company doesn't like to litigate. This company is not interested in this area. This is a very minor product as far as this company's portfolio is concerned, and therefore it's likely to be a minor risk. Same goes with trademarks. They may have a patent, but after a little bit of investigation, it may be that the patent we think is wholly invalid, and therefore we would consider it a lower risk because, frankly, it's not worth the paper it's written on. So the important thing really is not to be scared to move at all. It's really important to keep innovating and keep moving forward. And as we've said during the research phase, you're very clear to do so. It's just about taking some sensible preparatory steps before you take that jump to market. And investors are very savvy to this as well, because you don't have to take that jump to the commercial market on your own. And investors will, if you pitch to them for the appropriate sort of allocations, they understand the value of freedom to operate search. They understand the value of doing a bit of patent landscape and working out who's out there, what competitors are out there, because it's their money potentially on the line as well as yours. So pre-prepare for those things, think about it. And, if investors suggest, maybe we should do a freedom to operate search, budget that in, because you can find that you've actually got a really clear route to market and you've got a great niche for your product that nobody else is covering. And rather than launching at risk, bring those investors into discussions at early stages, explain to them the potential value, but explain the sensible steps you're looking to take to mitigate your risks before you go to full commercial production.
Yeah. So I think with freedom to operate, some people don't like doing them too early, but I think there's some value in doing some at least early, because then you're still early enough in product development to kind of design around. So if you find a blockage here, you can, all I need to do is make my oligo 5 times longer, and then you're not infringing. So they do little tweaks that perhaps you can do, that you can get around these obstacles, but only if you know that they're there. I don't need to go to this again just because of time.
So yeah, for the slide purposes, I mean, this is just things we think about for an IP strategy. We've talked about FTO. We love 3-letter acronyms, by the way, so hopefully they're all relatively clear. But talking about planning, have an explicit strategy, have a framework for dealing with potential problems. Who would deal with it? How would you deal with it? Who would you work with to resolve those problems? But just keep it there, because investors may well want to see that, and people who want to join the business with you, whether they're investing or not, may also want to see that. It's just good practice.
And people like us can help with IP strategies. It's what we do when we talk to new businesses. We help them get everything written down in a form that they can say, "Here, investor, this is my IP strategy." Same.
We'll make sure you've got these slides as well, because they're just fairly useful bullet points and sort of outlines of things.
Yeah. So this is I think this is like kind of aimed at scope of your patents, really. So this is like your territory. That's you've got various competitors doing different things. If you aim to protect just your product, that's not really that great, because you've still got all these other competitors free to act and do whatever they want to in the market. And you've probably got a fixed market and you want to get as much of that market as you can. As if you can broaden out your patent, which is our job, our job is to fight against the patent examiners to get you as broad a patent as we can. You want to try and basically, it feels awful coming from an academic background where everyone's supposed to share and collaborate, but really you want to squash all these competitors so you keep your space for yourself. So the broader your patent, the better. And you might have a load of different patents that all cover different things. And you can see these two are kind of covering different aspects of, say, your product, but then they're also knocking out different competitors. And there might be some instances where you want to protect something that actually doesn't really cover your product, but you know it's going to really annoy one of your main competitors. So they're all kind of things to think about in your strategy as well. And when you build into your experiments, when you're doing your work. So very briefly, the outline of the patent application. The main bit is the claims at the end. They're the bits that define what your patent, once it's granted, covers. And the claims are kind of generally interpreted in the context of the description. So the detailed description is very important. That kind of fleshes out. So in this example, we've got an E. coli cell and you've got a mutated exemplase enzyme. The detailed description will talk about what the exemplase is, different versions of it, different sequences. The examples are where your data will go, and they are kind of pretty much like the results and methods section of a journal article. That's kind of level of detail we'd be looking for there. And then you've got your figures. So I think I just put this in because I had a query from someone at one of the universities saying, does it have any data? Do we put examples in? It's like, yes, we do. We definitely need your data. So this was just, I'll just do this briefly. So this is an example of, say, an inventor comes to us and says, oh, I found if I make this certain mutation, S100P, in this enzyme in E. coli, we get really massive increase in catalytic activity. So what we could do is just draft a claim to that little narrow thing, but that's not really going to give you much protection. It's going to protect that specific protein, basically. So we'd want to, if you came to us with that data, we would want to say, does it work in other bacteria? You could probably test that quite easily. Does it work in yeast or other eukaryotes? Again, you could probably test that if they're the same enzyme. Importantly, are there any other mutations that are better or similar? Because we want to capture those, because you don't want to be stuck with this S100P mutation when Dave could go off and make another mutation somewhere else in the enzyme and not be infringing your patent. Another one that's really important, say the key mutation is this S100P mutation. We want to know, can you make mutations elsewhere in the protein and it still be as effective? Because what examiners are very keen on doing is limiting your claims to the actual data you've got. So if you've only ever got data for this S100P in an otherwise wild type enzyme, that's probably all you're going to get. What we like to do, and I'll come to the next claim, is try and get some variation in the sequence identity. So if we did just get data for the S100P mutation, but you'd made some mutations elsewhere in the enzyme and it still worked, then we could probably claim the enzyme with 90% sequence identity. So that gives some level of divergence and it's a broader claim scope. Can you use the enzyme in vitro systems? And also, what use does the enzyme have? So you made this great enzyme, what are you going to use it for? They're all the kind of questions we would want to know from you. And you might have got the answers, you might not have got the answers. You might be planning on doing some of that work in the next 12 months. So an ideal claim for us would be a cell expressing a mutant exemplase. That would be a really broad claim. It's not limited to any particular cell. So it could be E. coli, it could be yeast, it could be a liver cell, and any mutation in that enzyme. That's a really broad claim, and you're going to need a lot of data to support that. Otherwise, like I said, you're going to just end up with a claim to an E. coli cell with that particular enzyme defined by a particular sequence. So it's very narrow. So like I said, we need that extra data. They're just some example claims of what you might be able to get if you've got more data, and they are broader in different ways, but I'll leave them in the slides. So this is you at the bottom. Your main product is, I don't know, E. coli with the S100P exemplase. It's got a particular sequence. You're not really interested in making any variations in that. That's your thing. But you've got these competitors all over the place, which are using either HeLa cells or E. coli cells with a different mutation in the enzyme. And you don't want these guys doing all this stuff, because you want to, you know, it's your invention. You want to stop people doing it as much as you can. So, if up here we've got the really broad claim, a cell comprising mutated exemplars, that's going to stop all of these competitors, because a cell could be a HeLa cell, it could be E. coli, it could be yeast, and all the mutated enzymes fall within that scope. It's very broad, probably not going to get it unless you've done a lot of data, got a lot of data. But we could get an E. coli cell with a mutated enzyme, not defined in a particular sequence. That's going to stop competitors too being able to do what they want to do. If we go down to the really narrow thing, it's only stopping you, it's not affecting all your competitors. They're free to do what they want. But like I said, so with the sequence identity thing, that broadens it out enough to hopefully capture some competitors who might be using a slightly different sequence. So there's a lot of value basically in planning your experiments and little tweaks. So if you're making one enzyme mutation, just make one or two more. I know it's a bit of work, but just that little bit extra data can make a massive difference to what the examiners will allow. Do you want to talk about this?
Yeah, so the Scorcher approach, I think we're on the same page with that one. The other thing you can do, if you aren't minded to go and get a patent, you can ruin it for everyone else. So when we've talked about those broad journal publications, if you're thinking that you probably won't want to commercialize or take something forward, but you also don't want somebody to prevent you from doing research and development in that area going forward, you can publish all of your results and you can publish all of your data and make it available to everyone else. And from that point forward, you can be pretty comfortable that you can continue to do everything that fell within the scope of that publication. There are various defences in various jurisdictions worldwide that effectively support that, in that you can't infringe someone else's patent if all you're doing is putting into effect the teachings of something which is already in the public domain before that patent came along. So rather than protecting your area of the village, which I assume is kind of a dark picture you put in, you just burn the village and the forest around it down, apparently. So it's slightly less violent than that. It's much more just publishing the data, but it can be helpful, particularly as one of the earlier examples Sarah mentioned, is maybe trying to get a patent in a completely different sphere, but knowing that it'll stop your competitors from taking possession of that particular area. You can do exactly the same with a public disclosure. If you think that one of your competitors is getting close to a result on something you've already found all the data you need on, but you don't want to actually take it forward because it's not as good as your current product, you can publish that and prevent someone else from getting a patent after the date of that publication. So you can push that publication out to try and keep competitors out of the space, or disincentivize them from doing so because they won't be able to get a monopoly in that area.
Can I just check, have we got only until 7 o'clock?
Yeah, we can go a bit beyond that as well. So take questions if you have time.
Yeah, I mean, so if you wanted to, I think you mentioned incorporation a bit on the slides as well. So I think it's quite an interesting topic, but I'll run through it quite quickly. This is something that generally you'll want to speak to a corporate lawyer about. But generally speaking, there's lots of different models for building your business. I think one thing I'll say is, if you're a sole trader or you're working in your own name, the risks that you carry in going to the commercial market are far, far higher, because you are personally liable for anything that happens in relation to your product. You're also much harder to invest in because your assets are held by you as an individual. You don't have shares that exist in you. The normal way is sort of leveraging finance on the basis of those fixed assets. So you might find people effectively mortgaging your patents to give you money so you can then generate a business around it, which is not an ideal solution, because then somebody has a financial claim over your IP rights. What people commonly do is create a limited company which has a number of shares in, and the nice thing about that, and it's common for spin outs from universities as well, is that a number of interested parties can take percentages of the shareholding of that company, which then reflect their investment interest. So you can incorporate a limited company, which is solely generated to hold the IP you own, because it can hold it as a legal entity. And then people can invest in that company, which means that none of them individually owns the IP. The company still owns it, but each of them gets a share of the revenue by way of dividends in the success of the company as it proceeds. There are various different models and different ways of doing that. You can limit companies by guarantee, you can limit companies by shares, but generally speaking, I wouldn't go ahead as an individual or as an unincorporated partnership, because it gives you no level of protection against potential investors or potential liability going forward. So definitely getting advice from a corporate lawyer on the best method of incorporation for you. And there can also be tax implications. So the way a company is taxed on revenue is different to the way an individual is taxed on income. The way a company is taxed on assets and sales of assets is different to the way an individual is taxed on sales of assets. And a patent, for example, is an asset. So if you effectively generate income by selling that asset, you will pay tax on it. But you can seek tax advice and company law advice on the best way of maximizing the value you receive from your asset, where it's held, who it's held by, may even be a company in a different country. But these are all things to think about prior to filing, potentially, because you need to make sure that your patent is held as legal owner by the entity that you want to receive the value from this patent. So it's important to plan that all in advance.
There's like two more or one more minute of things I want to whiz through really quick, but I think you need to know. So to get a patent, your invention needs to be new, needs to be invented. For it to be new, it needs to not have been found in the prior art. And the prior art means any publication before the date of filing your application. That means journals, articles, talks, poster abstracts, anything. Most of the time we find problems with your own document. So you have published a journal article, put some little one line there like, oh, wouldn't it be great if we tried this? And then your thing is not new or inventive. One small difference is enough to make your invention new. And that small difference can also be enough to make it inventive. So we judge inventive step from what we call the skilled person. If you're actively doing research, you are more than the skilled person. So you need to take your kind of thinking down a little bit, as if you're kind of, I don't know, monotonously following instructions. Would that instruction lead you to your invention? Yes or no? If no, then you've probably got something inventive. Examples of new and inventive things could be just a different growth media, different buffer. One of our clients, a different position of a fluorophore in a probe makes it a lot brighter. Single amino acid change, all that kind of stuff. And data, the data you need for a patent application is not anything like the data you need for a journal article. So you can have a really rubbish looking wonky gel, that's fine, as long as it shows what we want to see. Don't spend forever repeating it to get a perfect gel, because patent examiners don't care. And that's it, I think.
Yeah, I've seen some terrible gels in my time, and the number of photocopies that they seem to have gone through is awful. Plausibility, again, you don't necessarily need absolute and incontrovertible proof that your invention works. The courts will allow an element of plausibility, as they call it, such that the data tends to show that the invention will work across an acceptable number of variants. So when Sarah talks about an 80% similarity in sequence, if you have a number of data points within that range that show up to a 20% modification works, then that is likely to be enough to render it plausible. You don't have to go through every single theoretical permutation of that sequence in order to demonstrate that your invention is in fact plausible. And a single example isn't necessarily going to be enough to destroy the invention itself if it's found not to work.
Can't think of it anymore. I know we're running out of time. I think me and Dave could probably talk for a lot longer, but I also want to answer your question. So we'll stop there and you can have a copy of these slides.
Yeah, awesome. Thank you for running through everything. we can take questions now. I think George would have been sending you the ones from the chat. If you see them.
Yeah, Sarah, I sent these to you in a direct message.
Okay.
Categories.
The ones in the chat, yeah?
Yeah.
How much should Startup's budget to maintain issued IP? So does this mean once it's actually granted, so renewal fees, which are every year, which vary, and I think they start off quite cheap, and then as the pattern gets older and older, they get a lot more expensive. But I'm sure in the first few years, they're just a few £100s.
Yeah. So,
sorry, Sarah. I think I sent these to you in a direct message. So if you could read out the question, just so everyone can
Where
follow
will
on.
that be?
okay, yeah.
Where's direct messages?
So yeah, it's come through on the chat directly to us. I don't so it's gone through the general chat. I think we're just seeing the general chat actually. So
Oh, here. Sorry.
yeah, great. Okay, so Julian's asked how much startups should budget to maintain issued IP per year. What about the roundabout price points for new packs and the follow-up costs? So that's really varies massively depending on which territories you're operating in. In terms of UK patents, I mean, so what would you ballpark? I mean,
To file, to draft, so most of the cost is in the actual drafting, because that's the bits where we're talking to you, working out what the invention is, trying to get it really broad, get all the language in there. £5,000 to £7,000 or £8,000 probably. That's kind of like on our reduced drafting. Some of them can be quite a bit more, but it is important to get it right. And it's important also to remember not all patent applications are created equally. If you pay somebody £2,000, you'll probably not get something that's going to have all the language in to get you a broad claim, because once you've filed it, essentially you can't add anything to it. So our job is to preempt what examiners might challenge us with, they might find in a prior art. Just one that I'm working on at the minute, basically it's microfluidics, so we've got a little gel bead and it's a compartment, and then the examiners come back with, well, a compartment could be a cell, a compartment could be an agar plate. No, it can't, but we need, that's kind of stuff we need to think about. What does a compartment actually mean, and what can people say it means? So yeah, basically make sure you get a good draft, because early on you're probably protecting your fundamental technology and your main ideas. You're going to have later filings that protect specific parts of that, but yeah. So for the first year, say you file a GB application between £5,000 and £7,000, and then 12 months later, you'll probably want to file a PCT application, which is an international application, which is another £5,000 to £7,000 again. And then after that, I think it's 18 months before, then you have to, I've got a slide on this with the timelines. That's when you have to decide which countries you want to go into, and that's when it gets expensive. A lot of people just go into Europe and the US, but some countries, some companies, if they've got the money, and depending where their like key markets are, we've just had one that's going into 18 different territories, and that was £84,000, I think. But that is 2.5 years away from now. And by then, hopefully we've got investors on board, which will help out with that.
In terms of the do I own my IP, so Julia's asked, what about presenting at conferences? Is it treated in the same way as publishing in context of patents? I'm going to caveat this answer slightly. Generally speaking, yes, it will be the same as publication. If you're in a room with a very small number of people, and it's basically done on a semi-confidential basis, then no, it might not be a publication. But generally speaking, if you're asked to present on an issue at a conference, assume that that will be a public disclosure of your invention, and therefore would stand as prior art. When we go through and look to invalidate patents, we do tend to look back through relevant conference notes, relevant publications related to conference notes from the years prior to filing, to try and find something that will then break that patent if possible.
Yeah, and I think especially under European case law, it's not, if I'm giving a presentation at a conference, it's not the words I'm saying that is the prior art, that's classed as a publication. It's more, I think there's case law on how somebody in the audience would interpret it, and if there were like any handouts and things. So if you presented at a conference, I wouldn't automatically assume that means you can't get anything granted. it's something to be aware of. And I think it's something, well, the examiners basically restrict to finding stuff online, basically. So if you can find a conference abstract, he's going to go with the abstract. I think the problem with these kind of public disclosures, but there's not really any proof, is probably more post-grant when, you know, you're making your millions and someone said, well, you spoke about that at the conference before you filed your patent application. Here's my notes. That's when it's going to be a problem, I think.
Okay, so Yushi Lee's asked about if you're a postdoc, your idea is unrelated to what you're doing in the lab with your supervisor, do IPs of the project enterprise still relate to the university? That's a really good question. Starting point is check the terms of your agreement with your university, because some of them will be broader than others, and some of them will say that everything you develop in a certain area will go to the university. The standard position under an employment contract is if it is unrelated to your job role and is not conducted with the assets or resources of your employer at all, it will generally fall outside. However, always go back to what the specific agreement with your sort of grant provider or your employer formally says. So always start there and then work back. It can be possible as well, if you deal with this early enough, to get a clear letter or other written acknowledgement from the university that if you're working in this particular area, that is not something the university is interested in, and you're doing that as an individual project. So you can get ahead of this rather than have to try and fight it later. So that's always quite a useful practical step you can take. Okay, oh, good, software question. Excellent. So Alina's asked, when talking about companies that create software programs, pipelines as a service or a product, what are the typical IP considerations besides the source code? Are there any challenges associated with IP? Well, in short, yes, there's lots. So different ways you can do this. Open source licenses are always really problematic. So be very careful as to whether you're using any open source software at all in your program. If you operate as software as a service, generally speaking, you won't have to disclose the source code, even if it has open source code in it, which is quite helpful. Confidentiality is always really, really useful. So make sure you have a very secure place where you're storing your code base, whether it's GitHub or otherwise. Record the dates on which you created it, because copyright arises automatically, and therefore if you don't have a written record with dates, authors and relevant information, which luckily for some of us now, GitHub, for example, will note who contributed what code, what time, but make sure you save all those logs, because proving creation, proving authorship and proving originality are always the most difficult things with software cases. So if you have good records in advance and you can prove when you created it, who created it, and what exactly they created, you're in a much better place than people who have to try and scramble back and do that in retrospect. Otherwise, if the software gives a technical effect, which is a super broad term, it may be patentable, particularly in the USA. But definitely speak to a software patent expert about that, particularly if it's an exciting bit of software.
Yeah. But is it the case, do you find that if you offer something as a service, a lot of the times it's benefit keeping that confidential, rather than, so if you had a and you like, I don't know, enzyme engineering, you might want to keep that confidential rather than make it public, because then anyone else can use it, and you have a hard time showing somebody is using your patented process behind closed doors.
Yes.
This is why patents granted to a product are much stronger than method patents, because it's easy to show someone's holding your product than they had you shutting their doors and using your method.
Using it behind the scenes. Yeah, I agree. So if you've got a programmatic way of screening, for example, you're better off keeping all of that screening in-house, selling the screening process to the end user and saying, we'll do it, we'll run the screening process and we'll give you the output, rather than giving them the ability to run the process themselves and potentially reverse engineer it. So there's different ways of keeping it safe that way. Okay, and then Akshay's asked, say one person designs something which is inventive, then another person follows the design experiment to collect the data, which person counts as the inventor? Okay, really good question. But effectively, if somebody is simply following a process and doing something that somebody else has told them to do, they are generally not going to be an inventor, because the inventive concept is what the first person's come up with. And if they've said, right, here's the structure, go and do it, all they're doing is following the sort of automaton approach that Sarah mentioned. What can change this is if you are told to go and run the process doesn't work, and you fix the process so that they get the output they're expecting. If you do that, make sure you note what you've done to fix the process, because that may well be an inventive contribution. Because what they thought was the invention, actually it wasn't. You fixed the process to improve it and make it better. And particularly if that's a non-obvious step to take, you just sort of go on a bit of a whim, but something you think might work, and it turns out that massively improves the process and fixes the problem, then you can also be inventor as well.
I think this is a good example of inventorship versus authorship, because both of these people will probably be co-authors on a paper, with the first person being the last author and the second person being the first author. But like they said, the second person probably would not be an inventor in this case.
Yeah, agreed. Great. Okay. Perfect. George, any more, or do you want us to maybe? Oh, actually, okay. There's a non-biotech question. Actually, I might have to answer that just because for variety. So Kelvin said, if you're an invention that relates to a medical instrument, should you be seeking a patent before talking to investors, or should you trust an NDA until you secure funding to file a patent application? That is a really good question. It depends how much you trust your investors. The main problem that you have at early stages is that an NDA will work to demonstrate that the inventive concept has been kept confidential. So you are allowed to talk to them about it without it breaking the ability to get a patent. However, what it doesn't do is provide you with funding that if that investor runs off with the idea and starts putting it into practice themselves, you would need to find a way to fund an action against that party. And that is not a cheap process. And it's a substantially more expensive process than getting an initial filing in for that patent. There are other steps you can take to protect your interest, which is very carefully limiting what you disclose. So you can talk to a patent attorney up front and basically say, what is the fundamental inventive concept in this medical instrument? If you can establish what that is at early stages, you can talk about it in very, very general terms, but without explaining exactly how it works. And that can sometimes be enough to get the investor interested, and you don't have to disclose that information, even under an NDA. You're not obliged to do so. So seeking a bit of early advice on how you would define your invention for a patent, even if you don't file just yet, can help you plan those conversations to give them just enough information to tease them to invest, but without giving them effectively the crown jewels of your invention. So a lot of it's about balance and giving them just enough information, but not too much.
And this is the same where if you do want to talk about your data at a conference, you can still talk about it, just don't talk about the core bits. Where this at the UK Symbio conference in Nottingham the other week, when somebody I worked with realised, oh God, we're talking about this, and actually there's something probably patentable in there. So we had a quick chat, worked out what the core bit was, and he just didn't talk about that. And his talk was totally fine. He did get asked about it, and he did say, I'm not allowed to talk about it. But yeah, so there are still ways of, going the academic route and talking about your work without giving away all the good stuff.
So yeah, apologies for running 10 minutes over, but hopefully
at least it wasn't 2 hours over.
At least it wasn't 2 hours over. Yeah, not that we've done that before or anything, but yeah, hopefully it's useful.
Okay, thank you so much. Thank you for all these amazing insights. And I think we have a much better idea of the kinds of rules that you should watch out for in your day-to-day research as in biotech, and how you can navigate the incredibly complicated patenting process, which I think is super important for all the people here that want to start biotech companies. I'm going to end the recording now, and I maybe ask Sarah and Dave to stay on for a little bit, but thank you everyone else, and have a lovely evening.